we have a really amazing supporter and sponsor of this track, Carpenter Wellington, who you're going to hear from in just a couple of minutes. We're really excited for them to be a part of this. This is their first time being at Austin Startup Week, and they are here to help you answer any legal questions that you have. They actually have a really cool booth in Hopin that you can check out from 12 to 1 p.m. today. We'll be dropping the link in the chat so that you can go there and get any questions answered that you have, the big burning questions about what you should do from a legal perspective for your startup. So really excited for you guys to meet them. Really excited about all the great sessions that we have today. And before we get to all of that stuff, we're going to actually have them hear a word from Carpenter Wellington. Ryan Carpenter, he is going to join us here on stage to kick things off. Ryan, welcome.
Thank you. Thanks, Sean, and welcome everyone. Good morning. Really excited to be here. As Sean mentioned, this is our first year partnering with Capital Factory and Startup Week. So thrilled to have us, and a shout out to all you guys at Capital Factory. You're doing a wonderful job. Really excited to have you attend today. We've put a lot of material in that we hope will be of use. I'm going to be joined by my colleague, Mario Glisic, momentarily. There he is. So we're Carpenter Wellington. We have an office downtown in Austin. We also have an office in Seattle and Portland, and we work extensively with startups and VCs from a broad range of positions, right from an idea to entity formation to bootstrapping right through. And we position ourselves uniquely in a way because we've spent many years working in-house in the legal team. So we've been there, we've partnered with business units, we've seen and contributed to growing the business. So we do understand the balance between maintaining your risk threshold and also making sure that you keep the lights on and you keep the revenue coming in and business tracks along. And that's a delicate balance sometimes. And so today we've got a track that we're really excited about. The first part of the track is kind of what we've positioned as a legal toolbox. And really this is just the broad sweep of everything that you can consider. Right. I will preface it by saying that given the time restraints, we can't do a deep dive. Everything that we're about to go into, we could spend 45 minutes in itself. But the intent really is to just give a broad brushstroke to just tidbits that you could give thought to and follow up with. The second part is a panel discussion where we're going to be talking with CEO of a startup, of a VC, with different perspectives around potential legal pitfalls. And then lastly, there's a discussion on the role of AI. So thrilled to have you. And unless Mario, you have anything else, I think we're probably ready to kick on. I know that we're a couple of minutes early, but we may as well get started if that's okay with Sean and the team. To presenting. All right, let's go. So, one moment, there we go. Okay, so as we mentioned, today's intent really is, with this particular presentation, is to just give a broad brushstroke, and we've done it somewhat chronologically. And what we mean by that is right from inception, early stage idea, right through to kind of you have your operations up and running and you're giving thought to kind of long term where your where your company's going to be positioned, whether you're going to be exiting or whether you're going to be going IPO. So next slide, please. Is that something? Oh, okay. Excuse me. I guess I have to change it. Okay. So, learning on the go here. Okay, so here we go. So this is what we're going to cover today. And like I said, it's going to be somewhat chronologically. We're going to give some thought to pre-company formation. There are some steps and thoughts before you actually jump in. And when you're starting a company or you have startup ideas, you start preparing and taking steps right from day one. Not simply, once you file your S corp or your LLC. And so we'll be going into that. We'll be discussing the entity formation, giving thoughts to that. the ownership and equity, what that distribution looks like, insurance, licensing, regulatory compliance. All of these are kind of the boring, vanilla type stuff you have to give thought to, but it's very, very important, because if it's overlooked, which it often is, it can really creep up unexpectedly. Intellectual property, a huge one. Not only what you're generating and how you're going to protect it, but also giving thought to perhaps what you're bringing in and what you're entitled to use as well. Capital raising and financing. We're going to briefly mention this, and I'll go over it kind of very broadly, but there has been a separate track that I would encourage you to revisit if able. So I don't want to replicate material, because there was a really good track a day or two ago. But we will mention it because we'd be remiss not to. Employees and contractors. Once your operations are up and running, and you're bringing in key personnel, there are some thoughts and considerations as to the type of engagement with resources. Whether it's employee or contractors. And then lastly, we'll be talking about your contracts and the way to effectively manage your contracts and the obligations within them. Because that will largely dictate how you position your business sometimes, and other considerations. So, all right, let's kick on. Okay, Mario.
All right. Well, thank you, Sean and Brian, for the introductions, and hello to all our guests. Thank you all for attending this event. Really excited to be here, and I hope it will be informative for everybody. I'll kick us off with this first topic, things for startups to consider before forming a company. So, business plan. Before you take any formal actions, it's really important to have a business plan. This will essentially be your roadmap for the development of the company, and it should identify your objectives and your detailed plans to achieve those objectives. So while it's not, it's not a legal requirement, it's an essential step for a startup that's looking to attract investors and provide direction to stakeholders. So a business plan typically should include, a summary of the business history, describing the background and experience of the management team, provide a detailed description of products and services that are going to be offered, provide a detailed profile of the target customers and any existing customer lists, analyze competition, market trends, provide financial analyses and growth projections, develop advertising and marketing strategies, include financial statements, listing assets, liabilities, budgets, timelines, and determining startup operating requirements and costs, including, employees, equipment, technology subscriptions, insurance, third-party services, all the things that you're going to need to run the business. The next topic to consider is whether you have any conflicts or non-competes. So before you start a business, it's really important to review your prior relationships and your activities, and make sure that there aren't any obligations or restrictions that could limit your freedom to conduct business with your new startup company. Essentially, that means reviewing your prior contracts, looking for surviving restrictions and obligations like non-disclosure, non-solicitation, or non-competition. An example would be some employment agreements will have non-competes, and those will restrict employees from starting a business that competes with their employer. Others might have a restriction on soliciting or hiring the employees. So make sure that you assess these risks before you kick off, especially if your new business is in any way tied to your former employer, or else you could be sued by your former employer. And then in line with ensuring that you don't have conflicts and restrictions, it's also important to make sure that you have rights to any intellectual property that you want to bring into the company. Most employment agreements have some form of clause that assigns intellectual property that's created by an employee to the employer while they're employed by the employer. And typically this relates to work that's connected with the employer's work in some way, but these clauses can be pretty broad. So, if you invented the next big Google on your employer's premises or on their time, there's a big chance that your employer could have rights to that invention. We see this a lot. People develop intellectual property while they're employed by their employer, then they decide to go off on their own with that IP. And this this could not only create major headaches before you even kick off with your business, it could be a dormant issue until later down the road when it gets discovered after your company becomes successful. And it could bring the entire company down if you don't actually have the rights to the intellectual property. So uncertainty around IP would also turn investors away. So it's really important that you have the necessary rights, especially if the IP is essential to the products and services that your company offers. And then finally, a quick but very important note on maintaining the company veil. This has to do with protecting yourself from liability. So before the company's formed, you got to make sure not to enter into agreements with third parties in your own name, because that will create personal liability on the founder. So in other words, make sure to establish the company formally before you get into contractual relationships, and then ensure that any signatures are on behalf of the company and not in your own personal name. Thank you. All right, so now moving into entity formation. One of the first things that you're going to have to decide when you create a company is the type of business entity that you're going to create. The most common ones are C corporations, S corporations, limited liability companies, and partnerships. And deciding which one is the best form for your business depends on many considerations. So for example, each type has different requirements and restrictions around ownership, the form of the equities, the formation and the governing documents and the rules, taxation of the company and its owners, liability, management, fiduciary duties, capital raising, and profit distributions. These are some of the major considerations when selecting a company structure. We don't really have the time to go over these in detail, but to raise one example of how different these are relating specifically to taxation. In a corporation, income taxing essentially occurs twice, once on the corporation as a legal entity, and then once on the shareholders when they realize profits. But on the other hand, limited liability companies and partnerships are not taxed as entities, so they're only taxed once when the members or partners, the owners, each pay their taxes on their own lawful share of the profits. So it's really important to consider these nuances carefully when you're selecting your business structure, so that it suits the needs of your business. So it's important in these areas to get counsel from legal professionals to understand full implications before you make this decision. The state of formation is also another choice that requires some consideration. While many startups elect to form their company in the state where they reside, there may be some benefits to selecting another state. One common state of incorporation, I'm sure that everyone is somewhat aware of that, is Delaware. And that's because they have a long history of corporate-friendly laws and judicial decisions that offer, certainty and predictability about how the company, is allowed to act and how it's going to be treated. But then there's also downsides like franchise taxes and very excessive reporting requirements that should be considered. Okay. All right. Selecting a name for the company. This requires a bit more than just settling on your favorite option. When you're selecting a name for your company, companies have to ensure that the name first isn't trademarked or taken by another company. And then also that it complies with the requirements of the state where you're forming your company. So for example, the chosen entity type is a limited liability company. Most state laws require that the name includes an indicator that it's a limited liability company, something like LLC at the end of the name, or just limited liability company. So it's really important to review these state laws to ensure compliance with the requirements, but also ensuring the availability of the name by searching, trademark databases, domain registrars, and just general internet searches to see if anybody else is using the name.
And Mario, I might just jump in there because it's important to clear the trading name. There may be legal entity name that's simply the name of the entity that you'd be entering into with formal contracts, but it's the trading name that has the public facing that may create the uncertainty or the confusion. We'd also recommend that from a product standpoint, you do the same thing, because in either case, if these steps aren't taken, then you're pouring money and time and resources into generating goodwill and trade name that may subsequently need to be walked back. So just a hint: don't necessarily do the legal entity name, but think about the name in which you'll be trading and kind of interfacing on a public level.
Yeah, absolutely. Thank you. Very important point. Okay, so when you're ready to formally register your company, you'll be doing that. In most states, the Secretary of State oversees business entities. So formal registration with the Secretary of State is required before you can begin conducting business legally. The registration is essentially the birth of the company. After that, the state recognizes its existence. The specific documents and the related requirements and fees depend on the type of entity that's being registered, and obviously on the specific state laws. If you're doing business in more than one state, you will have sort of a home state where you're registered, and then wherever else you do business, you're going to be required to register as well, and typically that's done as a foreign entity. So, for example, in Texas, a corporation is registered by filing articles of incorporation with the Secretary of State. There's a $300 filing fee, and then there's some minimum requirements that the articles have to include. So you have to state the name and the type of entity. You have to have a registered agent to receive service of process. You have to determine whether it's managed by a board of directors or pursuant to a shareholders agreement. You have to state declarations regarding the authorized shares and par value of the shares. Typically also need to state the purpose of the corporation. Normally just any legal purpose is sufficient. The effective date and identify the organizer. Typically attorneys are not required to file a registration, but it's recommended to ensure compliance with all of the requirements to make sure, especially with more complex business structure like a corporation, that nothing is missed on those documents. And registrations have to be typically maintained with regular filings. So it's usually required to file some sort of document every year or every other year that updates, or confirms that nothing has changed with the company, or if there's changes to the company, that those are on record with the Secretary of State. If these aren't filed on time, the state typically moves to administratively dissolve the company, which means it essentially gets closed down.
Okay, ownership. So typically there's articles of incorporation, operating agreement, or some form of charter documents that will govern the rights and the responsibilities of the shareholders and their relationship with the corporation. So it's really important to give thought to the makeup of those documents. And this is often overlooked. And what's really important to start with is the roles and responsibilities of the co-founders, because often co-founders may come in with an idea, they've got a product, and they just run with that, really focused on building that product, but they forget to have the discussion as to who's going to do what when. And that becomes really important particularly when you start getting financing or money, and operations start to scale. And it can really start to, if you don't have a clear meeting of the minds there, it can really start to breed a little bit of dissent. There can be discussion or confusion as to who's doing what. There can be unrest around someone doing more than someone else. So it's really important to establish the roles and responsibilities and who's going to be doing what. In addition to that, other agreements, you need to think about kind of procedural mechanisms as well, liquidity concerns, control rights, transferring equity, those kind of things. And there are other key provisions that are typically involved and included in an operating agreement that you're recommended to consult with a legal counsel. These can include drag-along rights, preemptive rights, rights of first refusal, deadlock. There's a few. So, my suggestion would be to not necessarily just take a pro forma operating agreement and put that in place, but which can have value, but understand the content within it. And to put an effective stockholder or operating agreement in place, you need to give thought to broader discussions and broader considerations. For example, what's the company's long-term plan, right? If there's a plan, for example, to go public, then we may need to include registration rights. If the makeup of the ownership is not necessarily 50-50, if it's going to be majority minority, then what does that look like? And equally as importantly, the operating agreements need to comply with applicable law, and they also need to be consistent with other governing documents. So there's a bit to consider there. But what I would recommend and what I recommend to clients is have these discussions up front. You'll save time and costs by getting on the same page and going into the attorney's office with bullet points, having already mapped this out, rather than having to kind of do it in real time. Equity, big issue, and we could dive in here. It's fundamentally important. And so what my intent here is to quickly kind of go over broad brushstroke, and if there's any questions, then obviously follow up with us. But equity grants typically consist of stock options, which give the holder, the optionee, the right to purchase a certain number of shares of stock. This is often very common with startups. They either come in the form of incentive stock options or non-qualified stock options. Typically, the holder will bear no investment risk until they exercise that option. So this is often used. Another option is the restricted stock, which is which comes with some contractual restraints. These could be, for example, the company reserving the right to repurchase the stock if the employee is terminated, for example. There may be other restrictions on resale or transfer of stock. So there are some thoughts around that. And then lastly, there are restricted stock options, or stock units, RSUs, which grant after vesting a specified number of shares of common stock. So there are options there, and this can often tie into an equity program that the company may want to give thought to. And an equity program works very effectively for startups because they want to retain good talent. They want to retain key employees, particularly in the early years where they're tracking upward. And so you got to give thought to what the equity grant for new hires are, for promotions and performance reviews. So there's a bit to consider there, and particularly with granting equity from startups, there are tax consequences for all the grants. And so depending on the nature of the grant, there can be significant tax consequences if certain steps aren't taken. So holistically, there's a lot to think about, and I would just encourage those co-founders to come in early and think about it holistically. There are other considerations as well that I'll briefly mention. There's considerations around Section 409A, which addresses non-qualified deferred comp. So there are certain steps to take, particularly around fair market value, to exempt companies from 409A. So a bit to think about there. I know that a few of you are probably thinking about the makeup of the cap table and how to effectively manage that. Kind of a two-pronged response there. Number one, I would encourage those to think about and start managing the cap table very early on, right? It's very difficult to try and reconcile that after the fact, and keep it simple. And then the second prong to that is watch the space. The second part of the legal track, the panel, we will be discussing the makeup and management of cap table more extensively than I'm doing here. So stick around.
All right, thank you. So I'm going to talk a bit about insurance licensing and regulatory compliance. We'll start with insurance and evaluating your insurance needs. So in most states, businesses are all required to have certain kinds of insurance. So like workers' compensation insurance is a requirement stemming from laws passed by the legislature and applicable to all businesses. This kind of insurance helps protect businesses and their employees from losses when an employee gets hurt, on the job, or gets sick from work-related causes. So make sure to check the legal requirements in your state to make sure that you're compliant with the minimum requirements for insurance. In addition to meeting the minimum legal requirements, businesses should also consider having expanded insurance to ensure protection during what is a vulnerable period of growth and development. But as the company grows, insurance remains important. In many cases, customers will also require you to have insurance before they get into a contractual relationship. So depending on the type of business that your company performs, you may simply have to have insurance just to satisfy customer requirements. So when you're considering the type and amount of insurance coverage to buy, companies should assess the nature of their activities and their employees and contractors, as well as exposure to customers and suppliers. So
really quick before we move on, I just wanted you to expand on the insurance. So you're meaning the insurance requirements typically outlined in a customer contract. Can you kind of give a broad overview of what you typically see from companies requiring and why they would require it?
Yeah, so again, it will depend on the type of business that you're in. So some of the common types of insurance that the customers will require and that are good to have. For example, if you're a technology company and you manage data, you may be required to have cyber liability insurance, which protects from losses stemming from data breaches or cyber incidents. There's also errors and omissions insurance, for example. This is important for professional services companies and often required by clients who hire companies to perform professional services. This protects from claims for losses that are suffered from inadequate work or negligence when the services are performed. And then there's also commercial general liability insurance, which most companies have. This protects the company from losses from third-party claims like property damage or bodily injury that occur on the company's property or from their operations. So these are some of the common ones. You'll see these oftentimes as requirements from clients, but it's also good to have that regardless of client requirements. All right, so registrations, business licenses, and permits, and taxes. So we discussed the formal registration of the company with the Secretary of State a bit earlier, but this filing alone is, in most cases, is not sufficient to have full authority to operate. It essentially just means that the company is registered. But in addition to the Secretary of State registration, the company most likely will need additional business licenses and permits. So in many states, a general business license at the state level is also required in addition to the registration to operate legally. In Texas, luckily Texas is open for business, so they don't require a general business license to operate. But there are a number of regulatory agencies that have licensing and permitting requirements, and usually it's based on the type of service or product that your company offers. So for example, providing legal or medical services, selling alcohol, and even running a barber shop requires additional licensing in almost every state. You also want to look out for local requirements. So many counties and municipalities also have their own business license or permit requirements. So depending on where your company does business, it may have to obtain multiple business licenses. And it's very critical that these are obtained, or else you could be facing pretty steep fines for non-compliance. Finally, on this topic, taxes. So, in addition to the federal income tax and related taxes through the IRS, your business is going to be subject to state and local taxes as well in most locations. The structures and requirements vary pretty widely across the country. But for example, in Austin, you need to register with the Texas Comptroller of Public Accounts. This is where you pay state and local sales tax. And then also check with the Travis County Appraisal District. This is where you pay property taxes if your business owns tangible property that's used to produce income in the Austin area. And the final topic here, regulatory compliance. So in addition to all of the registrations and licenses and permits and taxes, your business is also subject to certain laws that it has to comply with as it's doing business. Some of these will apply to almost all businesses, and others depend more on the nature of the business. So for example, compliance with labor and employment laws, both at state and federal level, is generally applicable to all businesses. And this includes, ensuring equal employment opportunities, non-discrimination, workplace health and safety, and similar standards like that. This is essential to avoid complaints by employees and contractors, which could be very costly. Then on the other hand, the specific nature of your business may also raise additional considerations. So for example, if your business processes personal information, again, for a technology company, you'd be required to comply with applicable data privacy laws. As an example, the California Consumer Privacy Act, the CCPA, and the General Data Protection Regulation, GDPR, these have very stringent requirements on how personal data is processed, and they provide pretty extensive rights to data subjects who are living in California and Europe. So regardless of where your company is located and where you're doing business from, if you handle the personal data of people in these locations, those laws will apply. And these laws are very strict, generally speaking. Non-compliance often carries very, very steep penalties. So it's very important to understand your obligations in that space.
Mario, I'm going to go back really quick with the business licenses, because I think it's important to note that this takes maintenance. This is not a one and done. So for example, as a startup or company grows, and they start extending their offerings and they have customers in different states, or they may have different key employees in different states. Every state and city and even municipality may have different business license requirements. And so you're generating revenue, or you have an employee in a certain state or city, there may be requirements to have a business license in that particular location. And so it's ongoing and it takes maintenance as well. So it's important to just keep note of that and periodically circle back internally and make sure that the maintenance of your business licenses kind of reflect your current day operations.
Yep, absolutely. Okay, intellectual property. This is a big topic. I wanted to start with just going over some of the basics of IP law. This is generally a term for diverse categories of intangible creations of the mind, and these are subject to ownership and other rights under state and federal law. So in the US, we have 4 general types of IP rights: copyrights, patents, trademarks, and trade secrets. I'll briefly go over the top 3 there. So copyrights are rights that are attached to original works of intellectual or artistic expression, and they protect the literal expression. So, for example, books, photographs, movies, music. These are some of the most common subject matter that's protected by copyright. But other works like software programs also get copyright protection, but it's limited in the sense that it only protects, with respect to software, the literal code itself. It doesn't protect necessarily the methodologies underneath. So that's something we'll discuss more with patents. But with respect to copyrights, the protection of a copyright allows the owner essentially to enjoy exclusive rights to reproduce their work, to distribute it, to display it and perform it. Copyrights can be registered with the U.S. Copyright Office, but registration is not required. The rights essentially arise immediately when a work is created, but registration is still recommended because it provides various benefits for the owner and it discourages infringement by others. Patents protect inventions such as new and useful products, processes, machines, devices, and designs. Obtaining a patent essentially gives the inventor exclusive rights to that patented invention and encourages technology investment and essentially reduces competition for them. Patents are regulated by the U.S. Patent and Trademark Office, and they have to be essentially obtained by applying to the office, and you go through a process to establish various requirements that need to be met in order for something to be patentable. So unlike copyrights, they don't attach as soon as the invention is created. You actually have to register them in order to receive those protections. And trademarks are used to identify and distinguish particular source or origin of goods and services, and they take the form of names, brands, symbols, slogans, colors, and even sounds. They're considered to represent the goodwill that the trademark owners have earned by marketing their products and their services. These are also regulated by the U.S. Patent and Trademark Office. And while you can have certain common law rights to these without registering them, by simply using them, especially over a longer period of time, registering the marks with the USPTO provides various benefits as well. And one of those is a presumption of validity, and then putting others on notice that your mark is unavailable. So when others are looking for a way to brand their products or services or their company, they can easily find that this is already a name that's not available anymore. So this is definitely also recommended when choosing a brand to first ensure that it's available so that you don't infringe on another company's rights, and then to also consider registering it for additional protection. So typically, companies whose employees and contractors develop intellectual property, they have agreements that classify any work product that's created as work for hire and essentially assigns ownership of the work to the company, to the employer. So this is certainly something that you want to make sure that you have in your employment agreements and in your contractor agreements. Those provisions need to be clear that the company is the sole and exclusive owner of intellectual property that's produced while the employee is working for the company. You can also, as I mentioned, then supplement that with registrations of patents, copyrights, and trademarks. And then consider registering to secure those rights. In addition to creating IP, though, you can also acquire IP by purchase. Ownership can be purchased of intellectual property, but intellectual property can also be licensed. So intellectual property that's acquired in title from third parties, you're going to want to make sure that you have a written instrument that's executed by both parties in the transaction. And then assignment transactions should also be recorded with the agency where the IP is registered. All of this helps to secure those rights and put a formal record on that. To manage your intellectual property, you should definitely develop a program that manages your IP and ensures that your rights are under consistent protection. You should maintain a list of all of your registered and unregistered intellectual property, together with all of your registrations, assignments, licenses, and other documents. You should collect and archive documents relating to inventorship, which is another important concept for resolving conflict between two patent applicants that are claiming the same invention. Development, use, and handling intellectual property, and particularly software, should be subject to a comprehensive company policy that advises employees on proper practices necessary to achieve IP goals and strategies. And then in terms of infringement, you can protect against other parties infringing on IP by implementing procedures that monitor and prevent that kind of misuse. You want to familiarize yourself with your competitors' products and then make decisions on whether their IP has potentially been infringed. So conducting searches of IP registrars, reviewing publications, and then just doing general internet searches to uncover misuse of IP is important. You can subscribe to various trade papers or industry-specific newsletters, which provide information about potential infringers, and that way you can stay informed and ready to react. Minimizing the risk of committing IP infringement of IP that's owned by others. You want to make sure that you train your employees about IP that's relevant to their industry, and then implement guidelines that are aimed at avoiding infringement. And then make sure that employees are, know these guidelines and comply with them.
Thanks, Mario. That's really important. So I know we're pressed for time. So capital raising and financing. As I mentioned earlier, there was a really great track a day or two ago, and so we don't want to necessarily go in and replicate what's already been discussed. But a few points, generally speaking. The type of instrument in terms of financing really depends on where the startup is in their stage of development. And that can depend on, like I said, a number of things, including the investor base and the financial position. Typically, startups follow the defined path that like a venture-backed startup typically follows, which would be the idea to the proof of concept, to actually building that out, and then scaling, and then maturing and exit in one way. And so really at each stage, whether it's bootstrapping to friends and family round to seed, whatever it is, it really depends on where you're placed in your startup. And so, in the interest of time, because again, this is something we could really do a deep dive into, we'll just give a very broad brushstroke, but a couple of things. Go to our website, carpenterwellington.com, and under the startup practice page, we've prepared a fairly comprehensive white paper that you can download, no obligations, that will detail each step. And so that hopefully should supplement kind of what I've just said and what's already been discussed previously. In terms of employees and contracting and managing, that's a really a discretionary call at the time. Employees obviously are subject to employment laws and obligations, and so there comes with those additional requirements. But then there are also additional costs that come along with it, payroll taxes and PTO and benefits, insurances. So it's a balance, really, right? Because it depends on if you have the capital to maintain it, but in the same respect, these resources want security. And if you go down the road of a contractor, then you're managing by way of contract, and then either party can typically terminate, which you can do, in an employment, because it's at will most times. But there's a sense of security when there's a W-2 relationship, and so that's a discretionary call. And so I just encourage those co-founders to give thought to those key positions that make sense in terms of engaging resources on a full-time, on an employment basis, because that's really investing in the resource and indicating to them that they are a key resource and that they're to be retained. The use of the contract is useful because you can again manage to the contract, which makes dismissal, particularly for the cause, much easier, because you're effectively terminating the contract and the procedural requirements of termination are clearly outlined. There are other considerations, but it does make it cleaner. But to be, in any event, and particularly the use of subcontractors as well, because there are often, if you're subcontracting out certain requirements, then you need to marry up the underlying contract with the subcontract and make sure that there are flow down rights and requirements. And so it does kind of piece together. And so, so I do recommend clients not just necessarily take a pro forma services agreement. They can be useful, but they do need to be scoped. And what we see often is that, co-founders, startups take a pro forma template that doesn't necessarily fit, and it can be problematic.
Okay. I think we're getting close to the end here, but I'm going to briefly talk about contracts and contract management. So first on the importance of contracts. Written contracts are really an essential tool to manage risk when you're engaging with third parties. So a startup should take steps to ensure that all third-party relationships are documented in writing, and should, as a policy, strictly prohibit verbal agreements with anybody, customers, suppliers, employees, even with friends with existing business contacts. While verbal agreements can sometimes be enforceable in court, it's a lot more difficult to establish what the parties agreed to verbally when they have a dispute over that. So if it's not recorded in writing, it's very difficult to enforce. To ensure that you can enforce your rights, make sure that document all relationships in writing. It's also highly advisable to create standard terms and conditions for the company, and to create templates for various types of contracts that are used over and over again. So this allows the company to be ready on the offensive with a set of terms and conditions that are favorable to the company, rather than to anticipate getting a contract from the other side, and then review contracts that are offered, which are almost always going to be favorable to that party. That just puts you in a bad negotiating position from the start. Creating standard terms and conditions is not just a job for your lawyer. It's really essential for business leaders to provide those necessary inputs, so that terms and conditions can be tailored for the company's specific needs. Many people view contracts as kind of a necessary evil. They look for templates on the internet, or use companies like LegalZoom to avoid cost and loss of time. But really, this is not recommended. These templates, in all likelihood, do not address the company needs, and would leave the company exposed. So it's important to invest early on to create these standard documents. For instance, non-disclosure agreements, employment agreements, customer agreements, supplier agreements, contractor agreements. These will be often used then. So it's a initial investment, but it really pays off in the future.
Yeah, Mario, if I could just jump in really quick, this is really important, in my opinion, for any company, but particularly startups, because it gives you the opportunity to position your contract tailored to what your product or your offering is, and also position it in a way that we can have quick engagement. Often what we see, particularly with those templates that are taken from whichever source, is that there's a significant overcompensation in the contractual positioning. And what this does is actually, if you're contracting with a sophisticated customer or other party, what this does is actually prolong the point of engagement or the point of like sale, because any sophisticated customer or third party is not going to accept those terms. And so what you'll get back are revisions, and then you have to start from there. If you have the ability to proactively position your contracts and certain positioning therein, then these are often more digestible by the other party, and you have a quicker sale, you have a quicker engagement. So I always encourage clients to try and really give thought to not necessarily giving away the farm per se, but taking a very tailored surgical approach to their standard terms that will ultimately serve them well. Not only because they'll get quick engagement, but also it helps with the contract management piece if you can standardize terms, which Mario will talk about in a minute. So sorry, I didn't mean to hijack, but I thought I'd add.
No, thanks. That's actually a good segue into the discussion around negotiating contracts. Having these templates, allows you to negotiate and be in a position of strength. But on the point of negotiation, it's really critical to actually negotiate rather than accept, whatever the other side is offering. Understandably, new startup businesses are often eager to get new clients. So oftentimes what I'm seeing is that they're ready to accept, whatever terms and conditions the customer is proposing in order to win the deal. And oftentimes they think that the terms and conditions are not negotiable. Sometimes the client says it's not negotiable, but that's usually not the case. Of course, you have to understand your leverage. That's a key factor to your ability to negotiate. But if you have a product or service that's unique, and the customer, may not have too many other options to achieve its business goals, then you have more leverage to get favorable terms and conditions. So I just want to make the point that, first, in any case, it's important to make sure that you review terms and conditions closely before accepting them, but to take the time to negotiate whenever that's possible, because it usually does lead to better results and helps you reduce the risk for your company. And then briefly on contract management, this is also critical to managing risk. This is essentially the process of managing, contract creation, execution, and then analysis, so that your operational and financial performance can be maximized while reducing business risks. It allows companies to manage their rights and obligations and ensure that they gain the most out of their relationships. So this really starts early, the contracting process, from generating a contract through presenting and negotiating the deal, going through approvals within the company, and then execution and storage and maintenance of obligations. This is if you establish a strong process around this, if you automate that process with a contract management tool early on in the business, it will save time and money in the future.
And I just add really quick, Mario, that the makeup of the contract and the management of your contract will be a big factor come the time that you want to approach investors, or come a time that you may be subject to, or you may be open to acquisition. the terms, how you've managed it. The terms are important because it will convey to the investor or the purchasing party, what their risk is that they're absorbing. And the contract management piece is important because it really is a demonstration of how tight ship you're running. If things are loosey-goosey, and you're not really sure of what obligations you have where, then that may give the impression that that's how you run your company. So it's important to put those things in place pretty early. Mario, we need to finish up. We've got a few questions that I've just got. So if you have any closing comments on this, let us know. Otherwise, let's kick on to the questions.
Thank you. I think you closed that up pretty well.
Cool. Well, thank you, everyone. Really appreciate it, and thank you for taking the time. There are our contact details and our pictures for your desktop backtops. Let us know if you have any questions. We've received a couple, actually a few, and so we'll try and get to those now. But we do encourage you and invite you to contact us directly. We're happy to set up time at no cost to kind of go over any questions you may have from this. So really quick, we've only got a few minutes, but I'll try and get to them as quickly as we can. Kevin asked, what is the role and what to cover in the founders agreement? Great question. I think we covered that a little bit, Kevin, but really fundamentally, what I'd encourage you to look at is, number one, the roles and responsibilities with your co-founders, making sure that there's clear delineation as to who's doing what. And then, the equity piece as well is really important. But doing it early is the most important thing. Doing it up front and being on the same page, pun somewhat intended, is really important. The second question we got is from John, who's asked, what are the three critical areas we should consider for legal assistance? Mario, what are your thoughts there?
I would say the planning stage, determining which kind of entity you want to establish. That can be fairly complex and has a ton of different considerations. I would certainly get help there. With respect to intellectual property, intellectual property can make or break a business, and making sure that it's well protected and that you've taken all of the necessary steps is critical. And I would say I would say with respect to making sure that you're compliant with registration requirements around business licenses and permits, those can also be fairly complex. They vary widely across the country and across the states, and can be very costly if you're not compliant with the regulatory requirements.
Yeah, sorry, I got kicked out there. So we have one more minute. I know that we have a few other questions. We will follow up with you directly after this if you've submitted a question. So I think in the interest of time, we'll probably have to keep it there. But we will follow up with anyone that has a question. We also have a booth that you're welcome to stop by. Both Mario and I will be there. And so please stop by and ask anything that you want. And we also invite you to follow up with us directly. But thank you very much. We really appreciate the opportunity, and over to you. Sure.
Awesome. Great job, guys. Thank you so much. And as Ryan mentioned, if you do have any other questions and would like to speak with Carpenter Wellington, they do have a booth in Hopin. We should be dropping that link in the chat. So be sure to go over there and check it out.